I took it upon myself to begin apologizing to the claimants for the wait that they had because it was over 2 years and just absolutely ridiculous. And it's appalling.
Hello, everyone. My name is Amanda, and I am the co-founder of Unbound Disability Claims. Today, we are speaking with recently retired Administrative Law Judge John Prince. We are going to be talking about what Social Security Disability or SSD hearings are like. Just a quick note, this is just one judge and his perspective, and we're not going to be giving out legal advice. We're not going to be speaking on behalf of the Social Security Administration. The goal of today's conversation is just to make you a little more comfortable on your upcoming hearing. So, welcome, Judge Prince.
Thank
And
you.
and how is your recent retirement? It's been what, about 4 or 5 days?
So it's day four of my retirement. I still don't know what I want to do when I grow up. Haven't figured that out yet. So retirement in and of itself for the last 3 days has been nice, but you know what? So far, yeah, retirement works. I kind of like it.
Well, that's great. Well, we stole you out of retirement just to do this interview, and I'm sure it's going to be helpful for a lot of claimants that have an upcoming hearing. So we're just going to jump into it and find out a little bit about your background. So tell us a little bit about your background and how long you served as an SSD administrative law judge.
Um, Criminal justice major at the University of Georgia. Didn't know what I wanted to do. Had interned at the district attorney's office in Augusta, Georgia. Somebody there said, "Well, the Defense Department is hiring for background investigators, and they call them special agents." And I thought, "Hey, special agent, that sounds pretty cool to me." Yeah. So I apply, I get the job, and I learned very, very quickly how to establish rapport with people because if you don't, you are going to struggle. You have to get people to open up to you about some of the most sensitive things. And, I would also do, we call them subject interviews, and they could be pretty emotionally fraught sometimes. And so I learned as I went and developed my own style. I had a boss who was actually very good at teaching me too. So um, I worked for the Defense Department for 2 years. Then I went to the Energy department to get a promotion. And after 3 years, I saw sort of a glass ceiling because nobody above me was going to be retiring or leaving anytime soon. So I thought, what can I do? I'll go to law school. So my father was a lawyer, his father was a lawyer. So it seemed like a reasonable thing to do. And when I went to law school, my vague thought was going back to the government. And I went into private practice for around a year. Uh, then the firm kind of disintegrated for reasons that are probably not relevant here. So one of my law school friends told me that Social Security was hiring, and they hired me as a attorney advisor, and I learned how to write the decisions of both disability and non-disability, and that was in 1996 when they hired me. And in 2004, uh, I was selected to be a senior attorney. So then I was issuing favorable decisions on my own with my own signature and writing the occasional complex case. Uh, then in 2007, Social Security, I beg your pardon, I should say, OPM opens up the register for ALJs, and all that is, it's a list. And they give people a chance to apply and to make it on there. So I didn't want to do it. I didn't think I would be picked because Social Security never really picked anybody from the inside. They wanted, for whatever reason, they wanted prosecutors and people like that. And the reason I kind of sound like I do is because these are non-adversarial hearings, and so what style questioning would be appropriate in a criminal courtroom is not going to be appropriate in a Social Security disability hearing room. It just they are two different animals entirely. So in any event, two friends talked me into applying. Lo and behold, I passed whatever OPM said I needed to pass, and so then I did the interview and I took a written test, and I got selected to, well, they asked me first. They called me in Raleigh, North Carolina, and asked, "Oh, do you want to be a ALJ in Cincinnati?" And I guess I was actually at home. And so I look at my wife and I say, "Do I?" And she thinks about it for 5 minutes. I'm sorry, 5 seconds, and says, "Yeah, we can do that." So in 2008, I came to the greater Cincinnati area. I'm actually in northern Kentucky, and I have been on the bench ever since. And I have to tell you, Amanda, it is what I think is the greatest job, a legal job in the government. It is. I got so much fulfillment out of it. I really did. These people oftentimes had not seen a human being in the process. It had been done on telephone or computer. And so I was the first human being basically that they saw who would be adjudicating their case. And I felt like it was incumbent upon me to make them as comfortable as I could and as relaxed as I could, particularly given how sensitive so much of this really is, because nobody wants to tell a room full of strangers about their physical or mental problems. It's humiliating, and so I felt like I was able to come across basically because of my past experience and let them know I'm absolutely sympathetic. It does not mean that I'm necessarily going to pay your case, but I am very sympathetic. And so I think I'm just going to conclude this by saying I felt like I was doing exactly what a good civil servant should do. And I never forgot who paid me. I never forgot that I needed to be respectful and courteous to these folks. They deserve that, if nothing else. I mean,
Yeah, that is a really good point that, typically the applicants wait, sometimes 2, 3 years to get to the hearing level. And
exactly.
um, you are the first person that they get to meet face to face that is making a decision on their case. So um, I'm really glad that you brought that up. So my next question would be, um, what do you think that claimants often misunderstand about your role as an administrative law judge?
I'm going to be honest with you, Amanda. I think people come in expecting Judge Judy, and that is totally not what we do. Judge Judy gets paid millions of dollars to be sort of a caricature. I try to tell them, look, this is not Judge Judy. If you watch any of the judge shows, this is not going to be like that. And then I'll try a little corny dad humor, and I'll say, and I want you to know, I am the nicest judge in this room. And usually that gets a little chuckle or a little smile, and they start to relax. And then for the folks who are hyperventilating, because you do get that, you get people who are just so nervous. And you say, all right, so this is what we're going to do. Just take a deep breath, let it out slowly. We're going to get through this. And Amanda, that approach, I think, worked better than any truth serum would ever work, and certainly any third degree that I might give them. Uh, the idea is that they know I don't have an agenda. My thumb is not on the scale one way or the other. And truthfully, it's not. My job is to apply, or was, to apply the facts to the law, or vice versa, and make the right decision in the right way for the right reasons. And that was my goal, to set them at ease, to let them know that I was neither Santa Claus nor the guardian of the trust fund. And I think, being straight with them helped. I think being sympathetic um, helped, and it wasn't false sympathy. I mean, I really did feel for these people, because that is such a difficult thing to do. I can't imagine how I would feel if I had to go into a courtroom or a hearing room with a bunch of strangers talking about some of the most agonizing or personal things that you can talk about, embarrassing. I mean, there are people who, in fact, I would say probably 95% of people don't want to be there. You're going to have just a few folks who are trying to run game, but that they've usually been weeded out by that time. And in fact, because the wait is so long, um, they just say, "Well, heck with it. I guess I'll get a job," and so we don't see them. And that reminds me, because I should have probably mentioned this before. So when I came on board in 2008 in Cincinnati, I took it upon myself to begin apologizing to the claimants for the wait that they had, because it was over 2 years, and just absolutely ridiculous. And it's appalling. And so I found out later, it wasn't long before the vocational experts began calling me the apologizing judge.
They need that. They need for, someone from the agency just to acknowledge
Absolutely.
that the system is broken.
Yeah.
And I mean, that probably just for someone to finally say that, I'm sorry. Obviously it's not your fault personally, but
Right.
just for someone to finally acknowledge that, that, I'm sorry that this has happened to you.
Thank you. Thank you. That's just who I am. And I'm one of these folks that I know the phrase people person is overused, but that probably literally describes me. I like people. And so I was all in favor of everything being calm and copacetic. And I could usually, in fact, most of the time, establish that sort of environment so that people would feel a little more comfortable. And as I say, it worked. I tried that third degree thing once or twice, and it just made the claimants clam up, because they didn't want to be attacked or feel like they were being attacked. And I don't blame them. I wouldn't want that either. And once again, we go back to these being non adversarial hearings. And so it wasn't me against them, it wasn't me against their attorney.
Yeah, I mean, there are judges out there that, they have that approach. And, when I've retired from representing, and, when we would, end up with those judges, I would tell the claimants, unfortunately, you've drawn this bad judge,
Right.
and, it's just the luck of the draw. Um, don't take, don't take any of what is going to happen at this hearing personally. We're
Mhm.
going to go there, do your very best. All I'm gonna do is reserve your right to appeal.
Right.
That's that's all we're gonna do at this hearing.
And you certainly were not going to get anywhere by arguing with the judge, because that just gets the judge's dander up. And I really probably shouldn't speak for any other judge, simply because we were so stovepiped. We didn't always know what the other judge was doing. And we would have lunch and talk about, oh, that's how you handle that. I said, okay, I got it. Um, I have had, oh, I guess probably over a couple of thousand hearings, maybe more. I don't know, but I do know that um, the VHRs would they would give feedback sometimes, whether you wanted it or not, but they would give feedback. And most often it was, I was in a hearing with Judge so and so, or sometimes I wouldn't mention the name, and he was rude and condescending and acted like the claimant was wasting his time. And I would just shake my head, Amanda, because they're not doing their job if they come across that way to the claimant. I'm just saying.
All right, well, we're gonna change gears, and we're gonna
Okay.
talk about um, understanding the hearing environment. So, what does the typical SSD um, hearing feel like from your perspective?
Well, so depending on where your hearing office is, you may have smaller hearing rooms, or which is what we had in the Cincinnati Enquirer building. We rented space there. The hearing rooms were pretty small, actually, and in fact, claimants or their reps might sometimes bump their head on the big TV on the back wall. They weren't very large. When we moved to the federal building, the hearing rooms were extremely large, more like what you would see in a federal courthouse. And that was um, that was good and bad. I mean, that it could be intimidating, I think, no matter how nice I am, because they're looking around and they're wondering. They had a guard that had, or guards downstairs that had searched them, and then there was a guard up front. And so, from my perspective, what I tried to do, Amanda, was, and this is the phrase I used, I tried to wear the robe lightly. Not be on an ego trip, not make these people feel any more uncomfortable than they might otherwise. It humanized the process. And so the hearing process for me, or the hearing environment, um, was one that absolutely looked like a courtroom, but um, there was not going to be any behavior that was intolerable.
Yeah, I've seen all kinds of things.
Well, yeah,
I've
you do
had
kind.
I've I've had claimants bring in like lounge, like lawn furniture, um, because that was the only type of chair that they were comfortable in for
Oh,
extended periods.
yeah,
Um, I've been doing this since 2003, so we've had hearings in hotel conference rooms
right.
and federal courthouses in the basement. I mean, we've had them all types of places. So
Sure.
yeah, but
Yeah,
yeah, I mean, nowadays, I mean, it is a little more like courtrooms. Um,
it is. Yeah. Although I think it's probably important to distinguish that you don't often get people, I think, in federal court, federal district court, coming in pajamas. But I've seen all manner of dress, and to be very honest with you, at first I thought, well, yeah, that's kind of disrespectful, and then I thought, okay, these people are more than likely in pain, whether it's mental or emotional. Sometimes it's just everything they can do to put one foot in front of the other. And so if they are exhausted after putting on, pajamas, you know what? I'm not going to rag them about that because they're here, and that's the most important thing. And plus, I didn't, you know, the protocols or formalities were just not my thing. And in fact, I think, and I can admit it now. So for the first 4 months as a judge, I wore a tie. After that, I realized nobody cared if I wore a tie. All I saw was the black robe, and I hate ties. And my goal in life is to never wear another tie again. So the judge job really worked out quite well for me. And whatever I do after this, no ties can be involved.
The only thing that, they are strict about in the courtrooms is, weapons. They do have security guards, they do a screening. And, a lot of the claimants, they do have difficulty getting around. So
Mm,
I would recommend that anyone before they go to a hearing, just make sure you don't have any knives, mace, anything like that, because you will have to go back out to your vehicle and, put those types of things away.
exactly. I'll tell you a very, very quick story. We had a claimant come in. The claimant was searched, of course, before the hearing, and the guard came to me with a bottle, and the bottle had some liquid in it. And so I said, "Okay, Jason, what do we got here?" And he says, "Well, this appears to be urine." And I said, "Well, that's interesting. Why would she do that?" He said, "She didn't really have an explanation." Uh, so what we ended up doing, to me, it was pretty clear that she was going to be using somebody else's urine for something that more than likely wasn't her own. And so I had to bring in the attorney at that point, and I had to say, "So your client uh, brought this in," and the guard with his glove has it in his hand. And I said, "We're not going to hold the hearing today. I don't think that's a good idea. We've lost a lot of time here. And so let me ask you, would you like this back?" And she looks at me and she said, "I have been practicing for 15 years. No one has ever asked me if I wanted my client's urine." I just, I died laughing because, yeah, that was such an odd situation. It happens. And so, among the things you don't bring, weapons or anything that could be used as a weapon, and anything that in this case was actually characterized as a biohazard and had to be uh, destroyed as such. And so, yeah, folks, just be really careful and don't tell me that the crack pipe is somebody else's and you picked up their jacket by mistake, because that's probably not true. And the record indicates that you have a history of this. So yeah, it's probably not a good idea to do that. But yet, Amanda, people will still surprise me. It happens. So yeah, I would say don't carry any contraband whatsoever. And even though in Ohio now marijuana is legal, but you know, federally speaking, it's not. So you don't bring it into a federal installation.
So, like I said, I retired in 2023. So are most of the hearings still happening by phone or video? And how does that change the experience of the hearings?
If I were the representative, I would want an in-person hearing. If my claimant were or client were to visibly show signs of illness or perhaps mental deterioration, leading them to be disheveled and unwashed. And I want the judge to, I want the judge to, assuming I'm the rep, I want the judge to see if this person has an abnormal gait when they walk into the room to the chair where they're going to sit in the desk. Um, I, honestly, there were some people I could smell, and that could also be an indication that their mental illness and particularly depression, because you have no motivation often, and hygiene. Taking a question or taking a shower is just, I just don't have the energy. I couldn't do it. So I've worn the same clothes for a month and I've not bathed. And yes, my partner tells me that I don't smell good, but I just don't have it in me. So there can be reasons for that. And it's not just somebody who's unhygienic on purpose. Typically, that's just not the situation. So if you have them there in front of you, you can also see better their reaction to questions, and I think that's telling. Now, COVID, of course, took away the in-person hearings. They are coming back, and there are some attorneys who are insisting on in-person hearings for their clients, and I understand why. Um, I would hold a hearing in any modality they wanted. If they wanted in person, I'd do that. If they wanted video, I'd do that. Phone, I'd do that. I'm just telling you that I think the more the judge can see and sense and hear and smell, usually that's not going to be something that's detrimental to the claimant. It may, in fact, help their case, depending on what their impairments are and the limitations that they're alleging.
I 100% agree. Um, so now we're gonna change gears again, and we're gonna talk about the tone and atmosphere. And um, you kind of hit on this earlier when you were talking about, you're not Judge Judy, and the hearings aren't like what you see on TV, Law and Order. Um,
Right.
so a lot of the claimants, before they go to the hearing, they're nervous because of what they see on TV,
Yep.
and they don't know what to expect. Um, can you talk about how you personally try to set the tone?
They come in. I nod my head, smile, say, please come on in, have a seat, and the hearing reporter would direct them where they needed to be sitting. And occasionally, at least early on, occasionally I would ask, how are you? And that's not a question you want to ask when you're not on the record, because you're going to get what is effectively testimony. And number two, it was a stupid question for me to ask. How well do you think I'm doing? I'm sitting in front of a whole bunch of strangers about to tell you my life story, which I may not be very proud of. So I stopped asking that question, but I did try to keep it light. I tried to be friendly, but not overly friendly, just simply because that wouldn't be appropriate. But I didn't want them to be scared. And Amanda, one of the things with the in-person hearings, you can see people who literally are shaking. They are that scared. And so, I told you I would have them take a deep breath. I would do the same thing. I would tell them, we're going to get through this. I promise. We're going to get through this. And so I think the attorneys appreciated that as well. And then I think when you give people that sort of consideration, you're going to get back better answers, more answers. And so I can't say that I was necessarily being altruistic because, my job is to find out the facts and to weigh them. Uh, so, Judge, and I'm going to quote my old friend Ralph Dodds, who is now sadly deceased, but he and I were selected at the same time. And I adopted Ralph's saying. He said, "Look, Judge is what I do, it's not who I am." And that just absolutely resonated with me. And so I would tell these people that very same thing. And there is a danger that it could backfire, that they could decide, oh, well, I can push this guy. Nah, nah, that didn't happen. These are not supposed to be adversarial hearings, and typically they're not. I mean, I can't speak for every judge, but I never held an adversarial hearing because it simply was not what we were supposed to do. And my particular skill set played well into an administrative hearing where there wasn't, me against the claimant or me against the attorney.
Well, when I was representing applicants, the way that I explained hearings to them is, it's just a conversation.
Yep.
The judge is going to ask you questions, you're going to give your answers. It's not like you see on TV, it's just you're going to have a conversation with the judge.
When I got the appointment, before I left Raleigh, I was asking everybody but the judges if they had any advice for me. So, and it wasn't because I was boycotting the judges, but I kind of knew what they would tell me. I wanted to find out what other people thought, and the very the most helpful person in my pursuit of learning what I should do was our security guard, Cynthia. And I told her, I said, Cynthia, I've been selected for this. Do you have any advice for me? And she said, John, I am glad you asked. She said, you have to remember these people, if they snap at you, it's not personal. They're scared, they're in pain. So Cynthia's advice really helped me put all of this into context and to appreciate just what the claimants were going through in this process that they may or may not understand in front of what we have been told is typically the highest government official most of these people will ever see or meet. And so, the answer was very clear to me: be nice, be respectful, be courteous, and it's okay to be compassionate. Just because you're compassionate does not mean you're going to pay the case, but you do need to treat these folks like human beings. You can't look at them or talk to them condescendingly. You can't look down at them. You're a public servant. You actually work for the public, so remember who your boss is. And I always tried to remember that. That was sometimes that robe can make you a little egotistic. Um, these things kind of help me not get my head too swollen. And if it did get too swollen, then I had colleagues who would sort of bring me back down.
That's really good advice. I think that's good for judges, for representatives. So we're going to change gears now.
Okay.
So we're going to talk about what judges are looking for. So, what kind of things did you look for as a judge, or when you were conducting hearings?
Okay. When I was conducting the hearing, so I would know what was in the file. I think I told you I felt like I knew it better than 95% of the reps, and so I would listen carefully to see if their testimony matched up with what was in the medical records. And as you know, there are things that doctors may not write down. There are things doctors may write down wrong. And so you have to give the claimant an opportunity to explain this. I don't see how you are giving them a fair chance if you don't give them an opportunity to respond. And so that's what I would do. And I would look for those things in the hearing because I had gone through the file. I would usually find some little nugget of interesting. There's an interesting fact about the claimant that the rep may or may not have known, but I knew, and I would say, "Well, I see here that you played violin in high school. That's really interesting." And the claimant would look at the representative, and they'd look at me. It's like, "Send a record." No, I just wanted to ask about it. So what that did was, I think it also reassured the claimant that I did know what their impairments were. I did know what was going on in that case. Um, and in the hearing itself, oftentimes the testimony is not going to be materially different from what's in the record. On the other hand, there are other occasions where it is absolutely contradictory. The young man who was claiming disability uh, for reasons I can't recall now, but he fell out of a tree while he was hunting. This was during the period he said he was disabled. And so I, of course, brought that up to him. And I mean, he'd been caught, it's in the record. And so he said, "Yeah, yeah, that happened." I said, "Well, I just wanted to hear it from you." And so those things, honestly, Amanda, uh, the hearings are what I view as my opportunity to just make sure that I'm not missing anything, and to give the claimant the opportunity to respond to things that could be negative in regard to their claim. I I feel like we absolutely owe that because you can't or you shouldn't just sandbag them in the decision when you didn't bring it up at the hearing. That is unfair. That is totally unfair. And so I tried my best not to do that. I'm not going to say that it didn't happen once in a while. The decision writer might find something that maybe I didn't see and add that in. And because I didn't see it, I didn't ask about it, and they put it in the decision. And so it happens. But I'm just basically looking for continuity, or I'm sorry, consistency between the testimony and the records. But knowing, as you also know, that the records can be awfully incomplete or awfully hard to read because there are still doctors who write in chicken scratch. They've not gone to the electronic systems yet. And yeah, I think I'm credibility is not really what we use anymore. We look at the consistency, um, and if they're inconsistent, I give them a chance to explain. If they don't take that, or if they um, let's say evade the truth a little bit. Um, okay, well, I gave him a chance, and so then I would note it in the record. But they always, I always try to give them the opportunity to respond to anything that could affect their case negatively. I mean, that's due process to me.
All right. So, are there any common mistakes that you would see claimants make? And what do you wish that claimants understood ahead of time?
So let me take the last part. Understanding ahead of time would be knowing that it's not Judge Judy, knowing that it's not some show where they're going to be heckled and humiliated. It's not going to be anything like that. Um, they need to know that going. They need to know it's not adversarial, and the representative should be telling them, this is the way it's supposed to work. This is the way it was designed. If things were going to get confrontational, and with this judge, I just don't see that happening. If there were, then I'm going to step up for you. Um, and that's what I would have expected any representative to do if I had gotten on my high horse and acted inappropriately by lording it over them, or just talking mean to them. That's when the representatives need to step up. So Amanda, I don't know that I would characterize anything as mistakes other than perhaps, not telling the truth, because if you're a judge who reads the record, and you understand the medical terms, you understand the impairments, and you understand the limitations that could reasonably arise from those conditions, uh, then you know don't don't lie about it. I want them to neither exaggerate nor to downplay what's going on. I just want the truth, and you know, if you're not going to give it to me, then there are going to be consequences. Just because it's going to be hard to find you disabled if there's a world of evidence that is contradicted by what you said at the hearing. And so mistakes is probably not necessary, other than what I just said. I don't think they make mistakes because I don't think they have planned it out so well. And I'm going to be very honest. I don't know how much preparation the claimant has had with their representative, and what they told them and what they haven't told them. At a minimum, I would expect the representative to brief them on the judge. Okay, so we know this judge, and this judge likes this, and this judge likes that, and so that's what we're going to try to do. I, 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 so claimant mistakes, no. Representative mistakes, yes, and that would be not being prepared for the hearing. Oh, that that got under my skin. I had someone who had served in a similar position to mine, who was representing an individual, and it was clear from the questions that were asked that the representative really did not know what was in the file. And so this representative was doing a terrible disservice to the claimant.
So when the claimant is preparing for the hearing, what are some ways that they can mentally and emotionally prepare for the hearing?
I think this also implicates the representative too, talking with them, briefing them about the process. Um, uh, they they should know, and unless the representative tells them, I don't guess they will know. They should know they're not going to say anything that will shock, surprise, disappoint, uh, any of those things to me. I mean, I've done background investigations and talked about pretty terrible stuff for, gosh, since actually 1986. So um, they're not. We're not there to embarrass them, and I will, tell them that, look, I know this may be difficult to talk about, but you're not going to say anything that's going to shock any of us. I mean, this is what we do for a living, so we're used to it. The claimant also needs to know that we talk in shortcuts. We use the agency jargon, and they may or may not get it. Usually they don't get it. What I would do is sort of the framework of my hearings was going through the 5-step sequential evaluation process. And so if I said to the representative, so is your theory that this is a step 3 case, or do you think it's a step 4/step 5? And the claimant would say, what's step 3? What's step 4? What's step? And then I would explain it to them. So they knew, what was going on. I think in terms of the claimant getting prepared for this, I I really have to say that it is just crucial for the representative to try to brief them not just on, oh, this is a nice judge, or this is a judge who may come across as kind of harsh, but to also explain, okay, so there's this 5-step process that has to be gone through, and the judge is going to be asking questions about that. Don't panic. I know the answers to these, and I will be happy to explain them to you either now or at the hearing or after the hearing. And so they're going to have to put some trust in their representative, because there's so much writing on this case for so many people. I mean, you you know, these checks are not the largest checks in the world that they get. But if you've got nothing, then $780 sounds pretty good every month. And so, yeah, if I could get that, maybe I get some Medicaid medical treatment. And um, they also need to be realistic. Um, Not everybody wins a case. It just not everybody is disabled within our rules.
When I was representing, the claimant has to be an active participant. In order for me to do my job, I need to get information from you. And in order for me to get information from you, I need to explain why I need that information. And if I explain why I need it, I feel like I'm going to get better information. Um, and when I'm prepping for the hearing, I want you to know my argument. I want you to know my backup argument, and I need for you to know what I'm doing. I don't want
Sure,
you to be confused during the hearing. I want you to know what's going on. And before I start anything, let me go ahead and address the negatives in the
absolutely.
case because I know that the judge has already he saw them already.
Oh, yeah.
And let me get those out of the way first, and then let's get to the meat of
Absolutely, absolutely. I mean, if you don't address it, I will. And you're going to look like maybe you were trying to hide that from me, which may or may not be the case, but I can only assume that there's a reason why you didn't bring that up.
Yeah, and I mean, the judge may not agree with my analysis of the negative, but I preserved my appeal, right? It's on the
Absolutely.
record.
Kudos to you for doing that, because you are helping your client. And I'm going to ask you a question now. So is it easier to win a case at a hearing, or is it easier to win it after the hearing?
Always prepared to lose.
And that's not a bad way to go, because you're looking ahead. And if you get a favorable decision, well, you know what? No harm, no foul. I prepared for something worse, and we got good news. So But you had asked originally about, dates and things like no, I don't even remember, hospitalizations and things of that nature. And if you have someone with, for instance, chronic pancreatitis who is still drinking and is hospitalized a lot, they're not going to remember how many times or how many days. And for a judge to expect someone with a vast medical record like that, and I'm thinking specifically of a case I had probably 12 years ago. It was no less than 17,000 pages of evidence.
All right. So going back to um, the hearings, and this happens during the hearings from time to time. Um, what should a claimant do if during the hearing, maybe they don't understand or they didn't hear you when you're asking a question? What should they do?
They should absolutely not be afraid to say, Judge, I'm sorry, I didn't catch that. Could you explain that or tell me that again? I'm not sure I understood. They should never, ever be afraid to ask the judge any questions whatsoever. And the judge should not be reluctant to answer any questions. I mean, transparency. It all goes to that. And so, if the claimant does not understand, and I would tell them, I'll be happy to, or if I ask them a question, I'll be happy to repeat the question. That is not a big deal. We'll just, work it out until you've got it. And once again, I can't speak for all judges, but I found that telling them that they were reassured and were not so shy about asking a question in fear of sounding dumb or what, because there aren't any dumb questions. Just ask it. And what I would tell them is at the beginning of the hearing. So if there's something you don't understand, it doesn't make sense to you, um, then your representative and I are going to try to find an answer. And if we can't find an answer, we're going to try to point you in the right direction to get that answer. These are not just files. These are not just electrons on the screen. These are people. These are their
Right.
lives. And you make the wrong decision, this person may end up on the street, they may end up dead. So, you have to know the consequences. And I'm really talking about the judge, but also the representatives. You have to know what the potential consequences are. And Amanda, that was why I tried so hard to make the right decision.
Now, do you expect for claimants to have perfect answers to your question or to say everything just right?
Absolutely not. I mean, we are all human and we all make mistakes. And you have to also not forget that they're in sort of a cauldron with all the pressure. They've been waiting for such a long time for this hearing and they are so invested in it. And so if they kind of trip over their tongue while they're trying to explain something, that's not a problem. I mean, it happens to all of us. So, no, they should not be worried about that. I mean, I'm an attorney of how many years, and do I always give the right answer and not maybe stumble a little bit? No, no. So I'm not going to expect anything more of the claimant than I would expect of myself. And in fact, I would cut them far more breaks because if they're in pain, or if they did not sleep, as I know you've heard, like 2 days before the hearing because they were so terrified, it's going to be hard to be articulate under those circumstances. So no, I wouldn't expect that.
Okay. Well, now we're going to change gears again. And, we've kind of talked about representatives, but can you explain the role of representatives if the claimant has one during the hearing?
So early on, from the beginning, practically, I would generally ask the questions, and then I would say, "Counselor, do you have anything in follow up?" And either they would or they wouldn't. And then I got to the point where I decided, all right, counselor, you need to make your money. I want you to question the claimant, and I'll follow up with anything I may have. And so, you know, if you had somebody who was, when I say somebody, the rep who was not as prepared as they should be, the next time they had a hearing with me, they were more prepared because they knew what I was going to do. And if they don't know what questions to ask, I mean, they are doing such a disservice to their client. And so I feel like in those situations, it was incumbent upon me to ask the claimant questions that would bring out the facts that I would need to know. I wasn't their attorney. I wasn't the government's attorney. I was a judge doing fact finding, and that's the way I viewed it. Was I thrilled? Probably not, but I they don't pay me to be thrilled. They pay me to do the right thing, and part of the right thing is to make sure that the information that's relevant in the case is brought out. And so, if you don't do it, I'm going to do it because I have to.
And also with adult cases, um, there were vocational or VEs present during the hearing. Can you explain their role during the hearing?
Well, they are supposed to answer any vocational related questions that you or I may have. They're they could be in response to hypotheticals, or there might be, of course, you go through the past relevant work with them and find out what the jobs are, transferability, if that's an issue, those sorts of things. So the vocational expert is not my expert, and he's not your expert. He's not the claimant's expert. He is an independent, impartial expert, and I can tell you with certainty that they're not trying to please me, and I don't think they're trying to please you. They're giving their honest opinion because, I don't want them to please me. I want them to tell me their real, honest opinion. And so there is no incentive for a VE to tilt their testimony in either direction, either the claimants or we'll say for the claimant or against the claimant, rather than for me. No, because I just want the truth, and that's what you want. I mean, it's what we're shooting for, and if the claimant, I beg your pardon, if the vocational expert cannot reasonably explain their answer, you've got every right and in fact an obligation to kind of hold their feet to the fire. And where did you get these numbers? How did you, what formula do you use? You got to do that. Yeah.
All right. So we have final few questions for you.
Yep.
Um, did you ever find yourself rooting for the claimant or wishing that you could say yes?
There were absolutely cases where I thought, you know, benefits would probably be very helpful, but the issue was the claimant did not meet the criteria for disability. And no matter how much I might feel sorry for him or sympathize with him, I can't grant benefits just because of that. Because again, I'm neither Santa Claus nor am I the guardian of the trust fund. That nice certificate they gave me back in 2008 doesn't say anything about those things. I'm supposed to make the right decision for the right reasons. And as far as rooting, I yeah, I don't think I would ever say I rooted for anybody, but there were certainly cases where I felt like the outcome was very appropriate and in some cases horribly overdue. And so I guess you could say maybe I was glad that these people had gotten justice. Um, but yeah, I as a judge wearing three hats, I couldn't root for them, and that would be wrong, and I wasn't going to do it. So I did my best not to deny anybody who met the criteria or to pay anybody who did not meet the criteria. It's important to me. Again, it's not my money; it's the taxpayers' money. It's the government's money.
And is there anything that you'd like to say to claimants who feel like they're not being believed or that the system is stacked against them?
Most judges really, I believe, are trying to do the right thing for the right reasons. We don't get paid more if we deny more. There's nothing, and I can say honestly, in 16 plus years, I never had anybody try to pressure me to make a decision one way or the other. No, nobody in management above me. The judges, the judges are given a lot of latitude to do that, and so I think you're going to get a fair hearing. So I will just end this by saying that I was honored and privileged to be able to be an administrative law judge with the Social Security Administration from 2008 to 2025. And I may not have always gotten it right, but it wasn't because I didn't try. And I'd do it again in a heartbeat. This has been a great ride.
Well, thank you so much.
Absolutely.
This is, I mean, this has been really, really great. And we really, really appreciate your time. And I think this is going to be so helpful to claimants that have an upcoming hearing, um, just to hear you and um, hear how you conducted your hearings and your perspective, and just reassuring them that you aren't Judge Judy, um,
Yep.
that you're not going to make fun of them or
No,
interrogate them or make them feel bad. That you're going to listen to them and give them a fair chance. And like you pointed out earlier, that this is the first time that they're able to speak to the person that is going to make a decision on their case. And again, Judge Prince, we really, really appreciate your time.
my
And
pleasure.
um, thank you for your many years of service.
Thank you.
And um, we really appreciate you watching. And everyone, have a great day.